Good afternoon. Thanks for jumping in. If you're on the West Coast, good morning. I hope your day is going great. Welcome to a happy Monday. Today we are talking about settlement in New Jersey workers' compensation cases. My goal today is to talk through some of the intricacies of this and answer as many questions as possible. Please remember, this presentation is for instructional purposes only and is not legal advice as to any particular matter. I also want to remind everyone to ask questions. I really love it when this is a dialogue and I get your fun questions. And in case you're wondering about the handouts that go along with this presentation, we are traveling through the handbook or the practice guide that I write for LexisNexis. So a lot of people may not know this, but I am the co-author, along with Rick Rubenstein, of the LexisNexis practice guide. We just got our 2024 edition, just came out, and it's fresh off the presses. I mean, it just came. We just got our author copies sent to us by the publisher. And so when I title this Chapter 16, is because as you go through this book, it's written from a dual perspective. And half the book is written by Rick and plaintiff's attorney perspective. And of course, I write the defense attorney perspective. So as we go through these topics, we try to give as fair and as balanced and as objective an overview of the workers' compensation law in New Jersey as possible. And I also include some of the materials from this in the handouts to this webinar presentation. So you have it in front of you, but I know it's complicated. There's a lot of case law citations in there and all sorts of things. And my goal for this presentation is to have a conversation, have a dialogue to explain and explore what these topics are and how they apply. And then, of course, to answer your questions. So please ask questions. You can type them into the box. That's why you're here live, right? And there are a lot of people here live, by the way. So please ask your questions. It makes it so much more fun. So we're going to go through the discussion about final settlement of a case. And this is really going to build on the other presentations, if you've been attending them regularly, that we've already talked about. How do we evaluate cases for exposure? What is an amicable settlement value? What do we look at? What's a permanent and total disability, and how is that evaluated? So you've got a lot of the sort of build up to today's presentation in the past. And so I'm going to talk about two things. First, we're going to look at it from the petitioner's attorney's perspective. How do they evaluate their case for making settlement demands and resolving their case? And then how does the respondent counsel do it? And I'm going to talk about the two types of settlements that we've already discussed. Section 22, or order approving settlement, which is subject to reopener, and Section 20, which is a lump sum dismissal and not subject to reopener. And again, we've already covered a lot of the stuff that's going to go into today's discussion: medical benefits, temporary disability benefits, permanency benefits, total benefits, death and dependency benefits. We've covered those in prior meetings. Let's talk about how we ultimately reach a resolution in our workers' compensation case. What does come into our settlements and what does not. And first thing I'm just going to start off with, remember, in a workers' compensation settlement, you can only resolve the issues that are before the workers' compensation judge. Private debts, private claims, contractual issues, employment issues, resignations, all of that stuff cannot be included in your settlement documentation because the workers' compensation court literally lacks jurisdiction over those topics. So when we talk about our final settlements or final judgments, remember, it can only address the permanent residual disability due to the petitioner, any medical treatment outstanding, or lost time compensation or temporary total disability compensation that's outstanding, attorney's fees, attorney costs, child support liens, because there is a provision for child support liens to be deducted from the proceeds of a workers' compensation case and paid directly to the probation department. Any liens and credits that we are able to obtain because there was a third-party settlement, and of course, medical bills. So that's what is the proper subject of a settlement. Now, the petitioner's counsel is going to have a different take on this than we are, and that's why I'm going to explore it from two different perspectives in this presentation. every settlement has to list or describe with specificity what the permanent impairment is that's being resolved. In general, wage loss does not come into effect when we are determining the amount of permanent residual disability, but everything else in a workers' compensation case is going to be resolved in that final settlement. And in fact, my advice is always do not resolve your case unless you're truly resolving everything in your case. Now, that doesn't mean that you can't resolve issues in a workers' compensation case by way of successive settlements in the same case. So, for example, you could do a Section 20 lump sum dismissal that just resolves one issue in the case. And you could do it multiple times. You could first resolve one body part, then another, and then you could resolve medical issues. But that's not our recommendation in general. By doing that, you are going to be reducing your overall leverage in the case. And it generally is not going to be something that we are going to recommend to our clients. So let's take a look at the case from the petitioner's perspective. What is the petitioner's perspective on settlement? What are their concerns and issues, and what are they trying to resolve? Well, petitioners want to resolve their cases by way of order approving settlement, pursuant to Section 22. Why? Well, those matters are subject to a reopener. These settlements have to be approved by a judge, which means that whatever the parties agree between the parties, a judge is also going to weigh in. The judge has to confirm specific things. They have to confirm that it is voluntary. In other words, the claimant understands the benefits that they are foregoing or the rights that they are giving up, including the right to trial. They have to approve the specific contents of the settlement, make sure the settlement is proportionate to the disability, meaning it is fair and just. Now, what's been interesting has been since lockdowns, more and more settlements are being done by way of affidavit. In other words, the petitioner no longer comes to court, no longer in person accepts the settlement, no longer in person signals that they voluntarily are accepting the settlement, no longer in person comes in and says, Judge, I understand I have the right to trial, but I'm giving up that right in return for today's settlement. And more settlements, much higher percentage, are being done by way of affidavit, in which the petitioner's counsel prepares an affidavit which says all those things, and then contributes it to the court alongside the final settlement order and lets the judge review it all on the papers. That has been how really predominantly we've now resolved cases since the lockdowns. Before 2020, that was really rare. And in fact, if the petitioner wanted to do a settlement by way of affidavit, they would have to explain why. They'd have to say, well, I reside out of state, or it's a big burden for me to come to court for an afternoon and accept my settlement. And it was, sometimes judges say, no, we're not doing it by affidavit. I want you to come in. I want to see you. I want you to verbally say these things on the record in front of me. But since lockdowns, that's really been the exception rather than the rule. In an accepted or admitted accident or occupational condition, the petitioner only has to prove that they have a permanent impairment that restricts the function of any body part or system, which lessens to the material degree their working ability. But that material degree in working ability doesn't actually have to be that they can't do their old job or they can't work. They only have to come into court and say, well, I can't pursue my ordinary activities of my life. And that's enough to satisfy the statutory standard. Now, there is case law that says merely parroting subjective complaints, that's just not enough. They have to be very specific to the case. And that's why when you see an affidavit or you observe a petitioner testify in furtherance of accepting their workers' compensation settlement, they will state on the record exactly what their condition is, what it means to them, what impact it's had on their life. So the most important part, if you're a petitioner's attorney, is trying to demonstrate how much disability the petitioner currently has. And obviously, because your attorney's fee is now 25%, they just increased 2 months ago the attorney's fee in workers' compensation cases to 25%, the petitioner's attorney has a vested interest in demonstrating the highest amount of permanent residual disability they can. How do they do this? Well, there's really going to be a couple things they're going to keep pointing the court to. They're going to keep saying, Judge, look at my expert report. It demonstrates a significant level of permanent residual disability. Judge, look how long this person was out of work. They were out of work for 2 years, Your Honor. That's a long time. They are entitled to a large award. And then the petitioner's counsel will focus on the ability of the petitioner to resume their prior employment. And there's two comments I'm going to make on this. First, the Workers' Compensation Act does not talk about their same employment, just any employment. That's number one. And the second thing is, the judge is supposed to disregard general working conditions or market conditions. And what that means is, hey, if we're in a recession, it's a bad economy, to come into court and say, yeah, I sprained my ankle 3 years ago, I was out of work for 2 years, and now I can't find a job. Well, the reason you can't find a job might be because the economy's in recession, or the type of employment you did is no longer available in this state. You know, maybe the legislature said, we're not building any more power plants, and you're a power plant engineer. Well, okay, you're not going to find a job doing that, right? So there are market conditions that we're able to argue would militate towards the judge not weighing that factor as highly. Now, the petitioner's counsel should also take into account, when they're formulating their settlement demand or the final settlement, how good is the defense to the claim, or the defense to the nature and extent of permanent residual disability. Where we have a great defense, typically those are the denied cases, disputed cases, challenged cases, cases in which we have argued are not compensable, maybe there's a lack of jurisdiction, or occupational disease cases. And that class of cases is the occupational exposure cases. We see the post-retirement cases being denied and disputed most frequently. Well, petitioner's counsel has got to really consider how strong their case is, how well they're going to be able to prove their case given the proofs they've already assembled. And they should be considering at this moment, hey, my case is not that strong. My witness is maybe not the best witness. The modus of injury, or the causal relationship, is weak. Maybe I should be formulating a Section 20, that's a lump sum dismissal, instead of trying to win a order approving settlement or a judgment in this case. And the things they should be considering when they're resolving their case should be, how risky is this litigation to me, the petitioner? How strong of a witness am I? What kind of proofs am I able to marshal? They should also be thinking about unpaid medicals and outstanding bills, because in a Section 20, that's going to end the employer or the respondent's obligation to pay for future medical and pay those outstanding bills. Issues regarding unpaid lost time, all those issues should be resolved at the time a Section 20 demand is made and a Section 20 resolution is reached in the workers' compensation case. How do they value cases like, for example, a dependency case? Remember, dependency claims usually are arising from heart attack, stroke, and cerebrovascular events. Those are harder for the petitioner to prove. So they should really be looking at the burden of proof that they have to sustain. And just remember, in a cerebrovascular case, a stroke case, or a cardiovascular case, a heart attack case, a ischemic event case, the burden of proof is on the petitioner to demonstrate that their work at that time was extraordinary, was beyond the normal work stress and life stress that they sustained, and led to that event. Well, that's a high burden of proof for the petitioner to prove. You know, often has to be proved forensically. Generally, those are going to be the weaker claims, but petitioner's counsel has to take into consideration the fact that the burden is on them in those cases. Now, in most workers' compensation cases, their burden of proof is, it happened at work, I'm claiming benefits, you pay me, right? But in cerebrovascular and cardiovascular cases, that burden shifts to the petitioner. And those are opportunities for us to attempt to resolve them by way of Section 20. Petitioner's counsel should also, in the death case where there might be a dependent, to consider what kind of dependents there are. And I'll talk about that a little bit more in full. Where do they determine the person's life expectancy in a total disability case, or the life expectancy of the surviving spouse in a dependency case? So all of those considerations need to be made. We talked last month about total disability cases, and we talked about the importance of establishing the correct average weekly wage and total rate, because that's going to determine how big this award is going to be. Remember, in a total case, the award is for an initial period of 450 weeks. And so calculating the correct average weekly wage and determining that is incredibly important in these matters. For the demand perspective, the demand of total, is the highest demand that can possibly be made. There isn't an opportunity to recover more than total disability. And so it's generally knowable, or it's generally obvious to the parties exactly what the potential exposure could be. I would also say that there is no cap on attorney's fees, but in general, judges will look at exorbitant attorney's fees demands, and sometimes will request that the petitioner's counsel provide an affidavit of services, particularly where that representation has been for a very short period of time and there's been very little work actually conducted. In general, when you're trying to determine how big the attorney's fee is going to be, it's usually 12%. Sorry, the attorney's fee is now 25% of the total award, but the way we determine it is we know that we're only going to have to pay 60% of that, meaning borne by the respondent. The judge will typically split fees in this jurisdiction. Other concerns about total disability cases, and again, we talked about total disability last month as a concept, and now we're talking about, well, how does it actually impact settlements or resolutions of cases? In the total disability case, the petitioner's attorney has to consider, hey, should I join the second injury fund? Because they have a statute of limitations to make that claim to join the second injury fund. They should also be considering if it's an odd lot case and what they'll have to do to produce the proofs and evidence, usually in the form of vocational proofs, to demonstrate an odd lot claim. And the last thing they have to consider when they're evaluating the total disability case is Social Security entitlement. Remember, where the claimant is Social Security entitled and under the age of 65, and they get a total disability award, our award is reduced or offset by the amount of the Social Security award. So it might not maximize the amount of money moving to the petitioner, and certainly the attorney's fee as well, if they don't take that into consideration. So all of those things are going to impact the evaluation and the settlement demand that you are going to receive from petitioner's counsel in these types of cases. Now, this is an interesting point. In order to reach settlement, most judges are going to require that the parties secure expert evaluations. Now, this is an interesting thing in this jurisdiction, and I'm going to stop for just a second and kind of go on a little bit of a rant. In this jurisdiction, there is no statutory or case law requirement for medical expert reports, but most judges of compensation are going to require them in order to establish the nature and extent of permanent residual disability. A judge will simply not say, well, it's a 50% of partial total case or 60% case, unless the parties get expert reports. So that's one thing. Now, I love judges. I think they're smart and they get to see a lot of cases, but not a lot of them will go out on a limb and call a case without there being expert reports. So it does incur some cost into the case. But the other interesting side of this is there's no formal guidance in this jurisdiction at all, nowhere, no statute, no case law, no regulations, no rules, not even an office memo from the chief judge has ever been written about how medical expert is to determine the nature and extent of permanency. And that should be shocking to many of you who practice in multiple jurisdictions like I do, because most jurisdictions have something, right? In the case of New York, where I practice, well, guess what? We have specific disability duration guidelines. It's published by the board itself and says, here, evaluating physician, here's how you're to evaluate injury. In the longshore context, right? Another area that I practice in, we use the American Medical Association guidelines for establishing disabilities. And many states have either established their own guidelines for experts to follow or adopted guidelines. You know, the American Academy of Orthopedic Surgeons have a set of guidelines, AMAs and other guidelines. You know, they've adopted something. Not New Jersey. New Jersey just says, we'll leave it up to the doctors, okay, with no guidance published and very little case law to guide these evaluators. So this jurisdiction follows no published standard at all for evaluating injuries. Petitioner's counsel is free to choose experts who will find the highest degree of disability that's plausible, without concern that these opinions will be challenged except by comparison. And what do I mean by that? What I mean by that is when I am cross-examining petitioners, I wish I could cross-examine their attorneys, I'm not. When I cross-examine their medical experts, I have to determine and figure out what system or what basis did you come up with for evaluating permanent disability. I mean, think how crazy that is. But that's how this system works. And what that does is it emboldens or entitles petitioner's counsel to go out and select physicians who they know are going to give the highest valuation of disability, because they also know this jurisdiction has no comparison tool or rules or regulations that we can confront that expert with and say, hey, this guy sprained his toe and you said he's totally disabled. You know that's crazy and violates the, oh, wait a second, there's no guidelines in this jurisdiction. Okay, so that's something unique to New Jersey that I like to stress or just kind of go on a little bit of a discussion about because that's a significant issue. However, they still have to pick an expert because, again, most judges are not going to approve or preside over a settlement where there are no expert opinions. And they need to have an expert opinion that's relatively objective and relatively scientifically based. What do I mean by that? Well, there can't be lots of typographical and inaccurate errors in the report. The doctor can't say crazy things in the report. There has to be some reference to objective scientific proofs or medical evidence of the claims that are made. The expert cannot simply parrot whatever the petitioner's attorney sends them. Did the expert even look at the medical records? Do they actually even look at the radiographic reports? Do they acknowledge that the person has pre-existing conditions? All of those things are now subject to cross-examination, are an issue in our workers' comp cases. Experts are now reimbursed $1,000 per report that they issue. Those are, by the way, petitioner's experts. So that's a recent increase. Just a few months ago, the maximum they could be reimbursed was only $600 a report. So this is a big increase, which means that petitioner's attorneys are going to have an easier time, we think, in finding experts who will be very happy to get a $1,000 paycheck for a 10-minute physical exam and writing a short report. I should also state that there is no standard as to what these permanency evaluation reports are supposed to look like. So petitioner's counsel is free to pick physicians who will write this report in any format that they choose. They could be long, they could be short, they could be very effusive and descriptive, or they can be just a couple sentences. It's really up to the petitioner's counsel and their expert. Now, I think that there's some interesting thoughts that the petitioners bring to these cases. And the first one is that disability and impairment are separate concepts. Now, my good friend, my co-author, Rick, who writes this from the petitioner's perspective, is, of course, trying to provide a theoretical or logical basis for why some of the most minor injuries that you will observe will have extremely high findings of permanent residual disability. I've also seen the opposite. I've seen people who are very, very, very injured, lots of physical injuries, but with low impairment because, hey, they're currently working full-time, full duty, and their doctor, the petitioner's expert, will come up with these giant findings of disability, and they would probably have written that they're totally disabled, except for they can't because the person's working full-time, full duty in the same role. My statement is that the consistency is the hobgoblin of the expert. And one of the most useful things you can do is to confront petitioner's experts when you're cross-examining them with their findings in other cases, because there is no consistency. In one case, the petitioner's expert will find that a fracture of the ulnar led to a 25% disability. In another case, they'll say it led to an 80% disability. That seems to me to be quite subjective, and for that reason, we think it is subject to cross-examination. Now, as you can tell, even when I try to put on my petitioner's hat and talk from the petitioner's perspective, I have trouble. So let's move over to where I'm more comfortable, which is assessing the value of the case from the respondent or the defense perspective. Our goal, of course, on the defense is quite different. We want to close as many cases via Section 20 as we possibly can. Section 20 is simply the section of the statute that allows us to close a case full and final. Section 20 settlement is not subject to reopener. However, remember that every settlement, regardless of under what statutory provision it's reached, has to be approved by a judge of compensation. Now, the statute says, and I'm quoting Section 20 here, it says, a judge may grant approval to a Section 20 where there is, quote, a question of jurisdiction, liability, causal relationship, or dependency of the petitioner, close quote. What does that mean? It means There are specific instances where the law acknowledges that where the petitioner has difficulty with their proofs, has a weak case, where there's a jurisdictional defense, the judge should approve these lump sum dismissals. Now, question and nature and extent of liability is really the nature and extent of permanent residual disability. Well, that's almost always in dispute. We're almost always going to have a medical expert who's going to find a smaller or less degree of permanent impairment than the petitioner's expert. So in my opinion, nearly any case, theoretically under Section 20, could be resolved by way of lump sum dismissal. However, the judges disagree. There is a powerful bias in our system against Section 20 lump sum dismissals, which again, I'll talk about in a little bit. But that prevents us from closing many of the cases by way of Section 20 that we would prefer to. And in fact, more than half of all cases settle by way of Section 22, which means they are subject to a reopener. Generally, when we're closing out a case by way of Section 20 or Section 22, we have to address things like child support liens, the amount of temp that's paid or maybe owing, any offsets that we would be entitled to, and of course, any reimbursements that we'd be entitled to from risk transfer opportunities. Now, I would tell you, if you're looking at your case population, there's some easy things that we could be looking at that you don't need to be a workers' compensation in New Jersey expert to look at to say, how am I going to evaluate these cases and which type of resolution am I going to obtain and what's the likely range of exposure? So one of the first things I look to is lost time from work. Remember, in this jurisdiction in New Jersey, we control and direct medical care, and that's important. Controlling and direct medical care means that we should be selecting the best physicians we can find, great networks. We should be working with motivated medical professionals whose goal is to restore function and get people back to work as fast as possible. So lost time from work should be minimized in the typical case. So I would tell you, lost time from work is going to be one of the most significant and most obvious indicators to you that you have a tough case or the exposure is going to be a little bit higher. The lost time is something that, generally speaking, with good medical management, we should be able to control. And again, I want us to be proactive. I want us to be in the driver's seat. So we should be controlling and directing that care to get that person back to work as fast as possible. So I would tell you one of your big red flag indicators is lots of lost time. Next, take a look at the kind of medical care that's been delivered to the petitioner. Has it been invasive or has it been passive? I'm not impressed by passive treatment. I'm not impressed by long physical therapy stays, lots of testing that doesn't go anywhere. I am more impressed with invasive curative care. To me, that is probably going to be more co-commitment with higher degrees of permanent physical impairment, because that's what we're really trying to get to in this jurisdiction. Diagnostics are important in this jurisdiction. Take a look at the diagnostics. How good are they? We look at diagnostics all the time, and I say to the judges, Judge, we don't compensate MRIs, but the truth is MRIs, objective testing, objective diagnostic testing are useful ways of determining how impaired or what kind of damage to structure or functions of the bodies has actually occurred. And the last thing I'll tell you is take a look at the social history, reporting to the clinicians during care. What do we know about this person's prior medical conditions, about the impediments to a successful recovery? All of that stuff is going to impact our overall exposure. Now, there's always going to be a contradiction between the experts. I've rarely seen, I can count on one hand, and I've been at this for a couple decades now, about the times that the medical experts hired by the plaintiffs and the medical experts hired by the defense agree. They rarely agree. And we understand that there is going to be some disputes. Hey, I already told you, these experts are not using any kind of uniform system for assessing disability at all. And it's not uncommon for my evaluator to say, hey, that's a finger injury, and their evaluator say, no, it's a hand injury, meaning there's a dispute about how even they're evaluating the condition itself, right? So that's going to be a common refrain that you're going to confront in this jurisdiction. Other issues are going to be things that we cannot maybe control, right? I can't control which venue your cases get placed into. That's going to be, your case is going to be venued either in the county where the claimant resides or the county where the employer resides if they don't reside in the state of New Jersey, which means the judge is going to be assigned by the Division of Workers' Compensation. We can't control the judge or their life experience. I can't control opposing counsel's skill and experience. And what I've discovered is that the less experienced petitioner's counsel is, usually the more unreasonable and outlandish their demands are, because particularly if they come from a context in a civil proceeding where they're used to winning $3 million in front of a jury, they come into workers' comp court and they think that those are the types of awards they're going to receive. Even worse yet than unreasonable or inexperienced petitioner's counsel is where there is no counsel, pro se cases. I literally defended a case in which the claimant pro se demanded, I'm not making this up, $1 billion to settle their case. Okay, that was a Austin Powers reference. If you're watching this on podcast, I just did the Austin Powers pinky to your mouth expectant face, right? How crazy. I mean, $1 billion is insane. So I will tell you that when it comes to evaluating exposures in cases, the skill of opposing party is going to be an important factor. Of course, we're going to take into account the severity of the injury. And of course, we're going to take into account the likeliness of how people are going to testify. And we should have a great sense of whether or not the petitioner is going to be a good testificant or not. Now, the other issue in this case, which is very interesting, or in this jurisdiction, I should say, is that New Jersey has what's called a whole man or impairment theory of workers' compensation. What that means is a petitioner does not have to show future wage loss in order to be entitled to an award for permanent partial disability. And none of the experts in the case will comment on future wage earning ability because it's simply not considered in this jurisdiction in any systemic or objective way. Now, my job is to show, hey, this was a minor injury. There was little lost time. The petitioner has resumed working in the same job, maybe in the same role. They have no restrictions in their working life. In other words, they're doing the same job. They don't have a helper. They're not using an assistive device. They're just doing their job, Judge. And by the way, Judge, they're currently making wages that are equal or even greater than the accident. Even if I can show all of those things, the judge can and will still award permanent residual disability to the petitioner because the petitioner could come into court and say some subjective statements. They can say, well, you're right, Judge. I am working the same job. I do have the same role. I'm not using any assistive devices. I don't have a helper. I am earning wages equal to what I happened before the accident. But Judge, what you don't know is on the weekends, I can't play as much golf as I used to because my back hurts from this workers' comp loss. And the judge can say, okay, well, there was no impact on your working ability. However, there was an impact on your personal activities of daily living, and I can still award a high degree of compensation for that. So be mindful that that is a jurisdictional peculiarity, and that's because of this impairment theory or whole man statute that we are dealing with. Now, once we get our permanency evaluation from our expert, we should not exchange it. We should not give it to opposing counsel first. We should wait until they get theirs, ask them for a copy of theirs. We get their permanency evaluation, and then I provide them with mine. And the reason for that is because there is nothing in the case law or the statute that prevents the parties from having their experts comment on each other's reports. And by the way, I do it if we have to go to trial. But when I am negotiating or resolving a case and we are evaluating it for exposure, I do not want opposing counsel to have a copy of my report first. It just gives them this opportunity to do some bad behavior, which is then go have their evaluator have the benefit of my report, and they will specifically, of course, contradict everything that my evaluating physician found. Now, because there is so much room here in New Jersey for subjectivity, again, there's no guideline as to how doctors are to evaluate permanent residual impairment, and of course, the judges are free to interpret that as they want, and of course, the judges do not have to find that there's any impairment of their working ability in order to award a large award. We have to be ready as a defense to contradict or to challenge the subjective complaints made by the petitioner. How do we do that? Well, we need information about their current activities of daily living. What's the best way to get that information? I would tell you, usually it's covert surveillance. Another good area is non-covert surveillance at their current job. I mean, they're currently working for us. There's no reason we can't grab our loss control cameras and grab some images of them currently working, obviously without any impairment, social media investigation, and then certainly going through all of the alternate sources. So when a petitioner is on the stand, they're testifying how they can't do anything and how disabled they are. I love to say, could you reach into your wallet? Do you have a driver's license? Do you have an unrestricted driver's license? Yeah, I do. Do you have a firearms permit? Do you have a hunting license? Do you have a fishing license? What kind of traveling have you been doing? Have you been going out of the country? Have you taking vacations? What kind of sporting life have you had? And sometimes they'll say things like, well, I used to be a gym rat. I used to work out in the gym all the time, but I'm not able to do that anymore. Okay, which gym were you a member of? Because we'll go and subpoena those gym records and we'll prove that you were never a gym rat. That's just a story you're making up. So it's not enough for them to say, I gave up a hobby or I'm not able to golf. When did you golf? Were you involved in leagues or tournaments? Were you just a hacker out there playing whenever you felt like it? Is there really a significant impact or not? And bringing that out in front of the judge. Now, certainly it can backfire if the petitioner really has had an impairment in their activities of daily living. But again, that's the exception rather than the rule. Some other mitigation strategies. Hey, what's their current job description? What are they currently doing now, right? I'd love to see how they're working now. I'd love to see, hey, judge, by the way, not only are they working the same job in the same role and for the same employer, but now they're actually they're requesting more overtime and they're working harder than ever, judge. How can they claim that there's been an impact on their ability? I also like to look at other issues like, hey, have they gone for their commercial driver's license renewal? And did they tell the evaluating physician in that context that they have all these alleged problems? Have they had training at the employer? Have they been certified on new equipment or new certifications? Demonstrates that there is not an impact on them. So really trying to be as comprehensive as we can be to mitigate our exposure in cases. Now, another class of cases are the denied cases. These are cases where we have a good jurisdictional or fact defense. And when we're thinking about defending these cases, we should be focusing first on how do we demonstrate or win on either the legal issue or the fact issue that we're trying to defend. Think about how you're going to present this defense. Often, we're presenting defenses, and particularly legal defenses, in our answering pleadings. But maybe it's better sometimes to reveal them or release them later in the case. Maybe we're not discovering that there's a jurisdiction or a legal defense until we're doing our routine discovery. But certainly think about the timing of raising certain defenses. Maybe you don't want to raise a defense until after the claimant goes and gets their expert report, and then you're ready to challenge their case. Or in the context of fraud or concealment, oftentimes we're waiting until the trial because there's a great surprise value to bringing those defense tactics out at play at the last moment. So be thoughtful about the sequencing of how you're defending and disputing cases. In a dependency case, in order to mitigate exposure, one of my most important things I'm going to do as defense counsel or as the employer's counsel is I am going to try to confirm that these dependents are actually the dependents of the petitioner. I can't tell you how many cases where, particularly death cases, where the claimant all of a sudden had family in other countries that were allegedly dependent. Now, we don't have to rely on their word. In an extraterritorial case, again, where the claimant says, oh, I lived in, I actually have a whole family and they're in Chihuahua and I've got a wife and 6 kids, which, by the way, would create a tremendous dependency exposure. Well, you need a marriage license. And I don't trust Mexican authorities to give us undocumented, not falsified documents. What do we do in those instances? Well, we don't just take someone's word for it. We would say, well, you need a birth certificate, and you need to take your Chihuahua birth certificate or marriage certificate, and you will bring it to the American embassy in that Mexican state, and you will have it actually certified as a legitimate document of that country, and then we can establish your dependency, right? We're not taking people's word for it. I've had other cases in which claimants alleged that they had they had actual dependents outside the country. They said, well, prove it. Show me that there was money going to them. It's not enough to say, well, my grandparents are still alive and they're in a foreign country. It's like, that's cute. That's great. I wish I had living grandparents. That would be amazing. but prove to me that you actually supported them. Where are the wires? Where's the money transfers? Where's the Western Union? Where are these things, right? So that is within our rights, and we should be using it. All right, next, the defense has got to be ready to attack the petitioner's experts. You have to attack on their qualification, attack on the history and the social history they obtained by the petitioner, attack on them trading reports amongst themselves, copy and pasting segments from their reports to each other. And I like to compare the complaints given to the treaters to the complaints that the petitioner actually had when they had reached maximum medical improvement. Often these things are completely different, or it's as if all of the medical care didn't happen and they went all the way back to the date of loss and explained how they felt when they were in the emergency room. Well, that's not proper foundation for an expert's opinion on permanent residual disability, and we have to be prepared to challenge that. We need to be thinking about their finding in regards to permanency. Is there a need for treatment? How good is our defense examination and our expert report? We're going to compare these two things. And unfortunately, I'm going to tell you again, because there are no guidelines, this is going to depend on the practical experience of your counsel or your risk professional, because adjusters see a million of these reports too, and to where this case is ultimately going to resolve. All right, let's talk about negotiating settlements. First, I'm going to talk about ethical duties. Remember, petitioner's counsel has an ethical duty to absolutely transmit any offers we make to their client. I can't tell you how angry it makes me when I make a settlement offer to opposing counsel and I said, look, your case is weak, but I'm going to be very generous here. I'm going to offer you $1,000 Section 20 to go away and never come back. And opposing counsel goes, they spit out their coffee and go, what? I'm never going to transmit. I'm never going to tell my client that offer. That's ridiculous. That offer's so low, I'm not even going to give it to my client. And I said, well, ethically you have to, so please do, and then come back to me, right? So just remember, even if you're making offers just to get the other side talking, they have to transmit it to their client under the rule of professional conduct 1.4. 2, I think we should be prepared to make the first offer when it's a Section 20 case. Why? Because so many opposing counsel are used to not having the Section 20 cases, right? The default position of the workers' compensation court is to be biased against Section 20 lump sum dismissals. I'll tell you that you should be prepared to make that offer, get that conversation going. Do not wait until you've already conferenced the case. I also believe that the judges are so captured that sometimes opposing counsel may not even want to discuss settlement with me until they conference the case with the judge. Why are they doing that? Well, so that the judge and opposing counsel can try to team up on me and they can become a litigation team together. Now, it doesn't work on me, but that's often done. There's certain counsel who every time I talk to them about settling a case, they go, yeah, no, we're not going to do it. Let's conference it with the judge. And the reason they're doing that is because they're allowing the judge to be the bad guy in the case. Okay, I know who they are and I know how they're going to operate, and we're going to, recognize that you're never going to get a high offer if that's your position, that, hey, I'll just wait to conference it with the judge, because they know the judge is always just going to add on 10% onto all of the suggestions or recommendations that they make. Not useful for me. We're very happy to try cases in that context. There is something in New Jersey that says that there is a 26-week limitation, that permanency evaluation should not be obtained until 26 weeks has elapsed from the date of loss. However, that is not really an impediment to Section 20. Generally, it's petitioner's counsel that is the barrier to a Section 20. In regards to third-party civil claims and liens, please note that it is our policy. I always am trying to resolve these issues as early as I can. I'm always going to come to my clients as early as I possibly can. I do think it's best practice to say, hey, how are we going to deal with this risk transfer opportunity? Again, we have an ethical obligation to work with counsel in the civil action, if there is one, to resolve any lien or reimbursement issues promptly. So we'll try to resolve that so it doesn't impede or slow down the resolution of our workers' compensation case. Okay, let's say, and this is quite typical, that an amicable settlement cannot be reached between the parties. What's our choices? Well, we can go to a pretrial conference with a judge of compensation and get their input. When we're walking into that conference, some of the things that we're going to need to be prepared with are, what is the date of maximum medical improvement? Is the case admitted? Is it denied? If it's denied, are there legal grounds? Are there factual grounds? Sort of the things we've already talked about. We're also going to need to think about how that award is going to be structured. When we talked about permanent partial disability a couple months ago, we talked about the availability of stacking in this jurisdiction. What that means is awards stack on top of each other. So 2 or 3 relatively minor injuries stacked on top of each other can yield a much higher award. So we need to be thoughtful about how the award is calculated. We're also going to need to be prepared to argue for credits for prior pre-existing disability. And remember, in this jurisdiction, one of the greatest parts about it, really, is you can get a credit for a pre-existing disability where there never was a prior workers' comp claim or a civil judgment. In other words, you can simply argue, Judge, the guy always had a limp. He had a limp for 20 years. He injured himself playing football in high school. And for that reason, Judge, we should get a credit, and half the overall resolution or settlement of this case should be attributed to the pre-existing condition. And the best part about that is you get the credit in today's dollars. So that's a powerful credit and offset right in this jurisdiction. And then finally, we need to be ready to argue about the nature and extent of permanent disability. I love Section 20 settlements. I can tell you when I wake up in the morning and put on my lawyer costume, I love these settlements, but I want to talk about 2 sort of things you need to be mindful of. Number 1, if you do a Section 20 resolution, a full and final lump sum dismissal with your employee, but they still work for you, you might be opening yourself up to them bringing the same claim again in the future. So in other words, the employee works for you, they claim they injured their back. You say, no, you didn't, knock it off. You had a pre-existing back condition and we didn't worsen it, and they agree. They say, okay, give me $5,000 Section 20, I'll go away. And you do, you pay them Section 20 money, $5,000. That does not stop them from coming back to work the next day, claiming they lifted a box of cardboard or something, lifted a pen, oh, I hurt my back again, and bringing the same claim again. So you have to be really mindful about doing lump sum dismissals with people who continue to work for you. That's going to be one barrier. The second barrier is, all right, well, we want to do a Section 20 with somebody, but we want to get them to resign as a part of the Section 20 so I don't have to worry about these repeat claims. You cannot put a resignation agreement directly into a Section 20 or any settlement. It's specifically prohibited under the Workers' Compensation Act, Section 39.1. Can you do a resignation agreement off to the side? Absolutely, you can. Again, they're rarely done in this jurisdiction, but you can do it. But you cannot put it right into that Section 20. Section 20 settlements, because they're so favorable to employers, are often paid at a premium. So if under an order approving settlement, the claimant was entitled to $100,000, you can expect to pay a small premium, maybe $110,000, for example, to do a Section 20 because you're obtaining some finality. Also, petitioner's counsel is not going to be a strong advocate for a Section 20 because it reduces their opportunity to do reopeners, which is part of their bread and butter. And also, you should be mindful that most judges have a bias against Section 20s. Why? Well, the court system prefers Section 22 agreements because they provide an opportunity for more claims in the future, mainly so it'll look like the court system has something to do, and they will clothe this bias in the statutory requirement to protect the petitioner. Again, imagining as if the petitioner did not have their own attorney in this jurisdiction, the judge will pretend that they're the petitioner's attorney, and the reason that they will not allow a Section 20 is because allegedly they're protecting the petitioner from their own choices. Now, again, I argue against this, as you can tell, quite spiritedly and animatedly, because I feel like, Judge, if they have their own attorney here who's advocating for this and the petitioner, want to do this, why are we standing in the way of it? Let's do a Section 20. As you can see, I'm a pretty passionate advocate on behalf of closing claims and closing them with finality. But again, this jurisdiction, that is the exception rather than the rule. Also, think about Section 20s is if you do not address unpaid medical bills or billing issues, that will not be resolved. That can potentially come back and haunt you. And the same thing with dependency claims. If a dependency claim is not specifically waived in a Section 20, then if the petitioner ultimately dies from something related to the work accident, their dependents can bring a dependency or death claim against you. So be mindful about that. Now, there's a workaround, which is when you're dealing with a case where there is a body system that's could potentially lead or be involved in death, for example, respiratory system cases, you can get a release from the potential dependents at the time of the Section 20, and there's case law that establishes that right. Another thing about Section 20s is, in general, you're closing the case full and final, and if you do not reserve specifically your rights to Section 40 lien transfer, you may be waiving them. So be mindful of that as well. And what we do is we simply place something on the order that says, respondent reserves all rights pursuant to NJSA 34:15-40, and we think that's sufficient. All right, some takeaways before I get to questions. First, the petitioner's goal is to maximize settlements, and it's actually encouraged by the Act, the lack of permanency guidelines, and the subjective nature of awards in this jurisdiction. Of course, we as respondents, we are going to try to obtain Section 20 settlements because they're full and final, and we have to do a lot of work to overcome judicial bias against these dismissals. Even when you're getting a Section 20 dismissal, though, respondent should guard against potential pitfalls. We talked about them just now, and protect the employer from future claims and issues. So that's what I hope to talk about today. Now, let's jump over here to questions, and I'm hoping I have some good questions from this group. Again, it doesn't have to be on this topic in specific, but I'd love it. All right, so first question I have, and I'm just going to go in the order the questions were received. Solana says, Greg, I'm only going to say your first name. I'm going to read your question out loud so everybody can see it, and then I'll answer it, okay? Solana says, Greg, is it safe to say that all denied claims, whether the burden of proof has been met or not, should have a permanency evaluation, especially if the goal is to resolve the claim via Section 20? No. No. Section 20 would not be required. You don't need a medical expert, for example, if you have a jurisdictional defense, right? Not my employee, didn't happen on my work site, happened in a different state, not a covered employment. You know, those are great jurisdictional or legal issues. I don't need a medical expert to establish those. I could establish that just by the proofs. I could put the petitioner on the stand and have them testify. So in those instances, no medical experts necessary. Minor injuries, laceration, cuts, bruises, burns. I don't need a medical expert to resolve those cases because they're minor. Burn cases in particular, laceration cases, you know, stuff that really shouldn't even be in the workers' compensation system, that we're going to use a Section 20 to resolve it. So it's not, I would say, a hard and fast or 100% every single time rule that you're going to need a medical expert. Is it useful in most of them? Yes, but again, I'm a lawyer, so I'm going to tell you about all the exceptions, and you know, we'll guide you, or we'll give you advice on what to do. All right, Miriam asked the question, Greg, if a petitioner after work injury attempts to work for other employers and has lost time due to the injury, will the petitioner be awarded for this lost time as well? Petitioner was no longer able to tolerate working, and case with workers' comp is still open. All right, great, interesting question. So they have a work injury with us. Hopefully we get them to maximum medical improvement, but then they go try to seek employment elsewhere and they're losing time. So the answer generally is no. Once we've got them to maximum medical improvement, the fact that they're having trouble with their new employer, or maybe they took on a job that they were not suited for, that's generally not going to be our exposure. Again, it's pretty rare, and I've rarely seen someone who is partially temporarily disabled or totally disabled from our employment go and seek work elsewhere. Because remember, in this jurisdiction, when you're partially temporarily disabled, you're entitled to total disability if the employer cannot accommodate. So again, that would be a rare circumstance. Once we get, our only obligation is to get the petitioner to maximum medical improvement. Then if they cannot work due to the sequelae of our workers' compensation injury, well, that's going to get resolved by way of permanency. So their activity at future employments that we don't control, lost time from employments we don't control, in general, will never compensate that. So that should not slow you down. Okay, Jim says, Greg, how do you respond if the petitioner's attorney asks you for our perm report before we have seen your report? I just say no. I don't mean to be terse, but I just say no, absolutely not. I say, get me your report and I'll give you mine. That's it. We have no legal obligation to turn over our permanency expert report until they've obtained theirs. Now, the situation is a little bit different if it's a need for treatment evaluation. In that circumstance, the beneficiary might be the petitioner, particularly if there is a finding by the evaluating physician that treatment is necessary. But in the permanency context, our expert's report is not discoverable. It's my work product until I decide to turn it over. And again, my answer to opposing counsel is just very straightforward. No, I'm not giving it to you until you get your report. Sorry. So that's the answer. All right, Jim says, Greg, if the the injured worker is quadriplegic, can we agree he's perm total without him getting his own attorney? If it's obvious, why get attorneys involved and pay fees? You're right, yeah, you can always stipulate to permanent total disability, no problem. In the case of quadriplegia, they're going to be deemed statutorily totally disabled under Section 12 and Section 36. That section says when there is a loss of any one hand and one foot, or two hands and 2 feet, the petitioner is permanently and totally disabled, period, end of story. So in the case of quadriplegia, and I don't mean to be light about this, that's a very significant injury and very rare. Yes, you should be almost immediately accepting the case, finding them to have a permanent total disability, and immediately starting to get the statutory caps going. The only benefit to stipulating to permanent total disability is that at 450 weeks, you'll have an opportunity to do a re-evaluation as to whether they're totally disabled. In my experience, these cases remain perm total forever. If you can try to resolve them without them getting a lawyer, that's great, because the only thing the lawyer is going to do for them in that case is take a 25% fee. There's really nothing for them to do because they're statutorily, totally, and permanently disabled. So great question. Okay, great questions today. Thank you for asking them. That's all we have today. And thank you for all of you. And there's a lot of you who stuck around until the very end. So thank you for coming. Next month, I can't wait to talk about our next topic, and I will see you then. Have a great rest of your week, everybody. Enjoy the weather.